Good morning. Welcome to the Light on Suitability podcast. I'm your host, Elizabeth Comeau. I have with me today special host Mike Gawlik and Joseph Haytas. He's basically the star of the show, been the star of the show for the last 18 episodes, because we are talking about his book called 36 Strategies of Suitability. And I don't know why I didn't remember that. And we are going to get into strategy 19. So we're more than halfway through this book. And today is navigating parole hearings from preliminary matters to decision. And there's Mike, let him back in. And I gotta say, I did not review. I have had a September that's gone crazy on me, so I didn't even review the chapter. But I kind of know what's going on from preliminary matters to decisions. So why don't you take it away, Joe? It's kind of self-explanatory a little bit, but then we'll get more into the nuance as to why it's important to understand all this stuff and go from there.
Yes, thank you. This is a good area, and the reason I made this part of the book was because of the fact that people go to a hearing, especially an initial hearing, and they're not sure when they're going to be asked certain questions, like from certain areas, like when are they going to discuss my disciplines? Except that's one of the exceptions to the rule, and I'll get into that. So think of hearing procedure as before, during, and after. First, they talk about everything that happened. The commissioners, the commissioner discusses your personal history, your any prior crimes you may have had, and then, of course, the commitment offense. Then they move on, and the deputy commissioner discusses all the things that have been going on in prison, meaning, your disciplines, of course, discusses your work history, any vocations you've done, any education you've accomplished, work assignments, and programming, of course, and then disciplines. Then the deputy commissioner also discusses parole plans. That's the after of the before, during, and after. That's the after prison. It's going to be in the future. And then after that are follow-up questions from the DA, if the DA appeared and wants to ask questions. And then from the person's own attorney, the incarcerated person's own attorney asks follow-up questions, sometimes if appropriate, of course. Then there's closing statements. The DA makes a closing statement. The incarcerated person's attorney makes a closing statement, and then the incarcerated person has the option of making a closing statement. Usually the incarcerated person will say something, or they can rely upon whatever their attorney stated. And then after close, and then of course, if a victim or a victim's next of kin is present and they wish to make a closing statement, that's the time to give it. Then after that, the commissioners go and deliberate. They come back with their decision, either a grant or a denial. If it's a denial, it's for either 3, 5, 7, 10, or 15 years. The decision is read. And if it's a denial, then, in either case, the incarcerated person will be given a transcript of the hearing in approximately 30 days. And if they were denied, they can use that transcript as a checklist or a roadmap, if you will, to their next hearing, because the commissioners like to point out your weaknesses and things you need to work on and what you should be doing before the next hearing. So that is that is hearing procedure. That is the steps that it takes place in. And as I said in the beginning, there's an exception for recent disciplines. They start these hearings out discussing the discipline if it's fairly recent, and if there's more than one, because those persons should probably waive their hearing to get some discipline free time before going to a hearing and expecting a grant. So that's hearing procedure from beginning to end.
Really good. And I think it's really important for people to understand the procedure so that you walk in knowing what to expect rather than wondering what's going to happen. And that, just have your loved one ask the attorney, because sometimes we assume everything that you kind of know, because in groups you guys talk, they talk about a lot of different stuff. But it is important to know that if you haven't waived your hearing in the face of your loved one hasn't waived his or her hearing in the face of a recent write-up, you're going to be on the hot seat for that, likely right up front with most of these commissioners now, because they're already denying you parole. They're already saying, look, we're going to rely heavily on documentation. Not heavily, but that's not the right word. We're going to take your documents, and instead of asking you about things in the documents and have you regurgitate, we're going to ask you to clarify and or maybe test you to see if you've internalized what's in there. But in general, like parole plan stuff, certificates, they're not there to just list off your programming. A lot of people think that it's all about, how many certificates I have and that I checked all the boxes that they asked me to check, versus, okay, now tell us what you've learned and applied to that. So that's going to be what they're really after. And another reason to know kind of what Joe's saying about coming in there and realizing that they're about to put you on the hot seat if you're coming to this hearing and you haven't stipulated or waived in the face of a very recent write-up, and that is you're going to be asked about this write-up, and it's going to set the tone. Another thing about these hearings is that first 15-20 minutes after the Americans with Disabilities Act rights section, where they ask you about all of your rights and all of the accommodations, is really, it's a judging a book by its cover. Those commissioners, I feel, have kind of made up, they have a tentative decision made up for the case over the weekend or whenever they've prepped it, and they've judged it by the paperwork, but not entirely. They still reserve, of course, like a judge who gets a motion, gets the motion, the opposing paperwork, reply paperwork, the evidence. He or she isn't hasn't made the decision isn't final, but they're oftentimes a tentative decision. And tentatively, when I look at your risk assessment, and it's a higher end of moderate, and I look at your disciplinary history, and it's riddled with disciplines and continuous disciplines and recent write-ups, whether they be counseling, administrative, and or serious, and the type of serious disciplines. And we look at your programming, and you have some programming, but you don't have targeted programming that really speaks to the nature and magnitude of the crime you committed. Okay. And we go back to the risk assessment, and you also don't have a deep understanding of why you committed the crime, an understanding of your character defects, no real internalization of their 12-step work. You're not somebody that they have put you like in their maybe column of going to uphold the grant. Because remember, the legal standard is you're presumed to go to that hearing as a grant of parole, basically. You're presumed releasable. And then they talk to you, And then they have to show that the presumption, they have to overcome the presumption that you're releasable. How do they do that? Recent disciplines, lack of insight, lack of programming, etc. So that's actually not a very well understood standard, but it is. You sit there just like a defendant in a trial. He sits there presumed innocent, meaning not guilty. Now, you never walk away innocent, but it's then the prosecutor has to say, okay, he's presumed innocent, but please consider this, and please consider that, jury. And then tell us, do you think that we have overcome that presumption? So it's the burden is actually on the commissioners to find ways that the person sitting before them is not suitable for parole. So this is really important for people to understand. And then if you know this, if you know that getting into that hearing and right off the bat, there's already sort of this tentative idea about how they could overcome the presumption, because they don't want to overcome the presumption. They want to support the presumption with programming, with discipline-free time, with insight, with parole planning, relapse prevention planning, and that sort of thing. They want that. That everybody wants the feel-good thing. They don't want to just deny people. So
Right.
I'm going to mute Mike. So hang on. I can't mute him. So then finally, you're going to have to know that, because otherwise it can throw you a bit off kilter. So then they're going to get the evidence that they want to support probably their tentative. Now, sometimes they will admit that, you know what, Mr. So-and-so or Mrs. So-and-so, I came in here thinking this was going to be a denial, and, you really present very well on paper. Or the other thing that is necessary is if you kind of know that it's going to be a denial, but you really want to give it that, you really want to try, okay, not to be granted parole necessarily, but you're like, I really want to put it all out on the table now and really walk away with a 3-year denial on a moderate risk assessment because you're missing something, but you really want to try it because it's part of the journey. It's part of a step 5. Tell somebody the exact nature of your wrongs. It's part of a step 8. It's part of a step 9. It really is. It's part of step 1. It is part of your step work. And some of the commissioners understand that and some of them do not. It also can be extremely important to have that best foot forward in that first 30 minutes to just come out right out of the gate. Because if you don't have recent disciplines, the next thing right out of the gate is going to start asking you about accountability and how accountability is expressed at the beginning of the hearing. Again, sets that tone for how they view you. So if you come and say, what happened on the day of the life crime, and say, well, my wife was giving me a bad time all day and the kids were screaming and everything was going wrong and I just lost my job, and we're sentences and we're minutes in and I still haven't heard what happened to the victim and what you did that makes you responsible for it. Not a really great presentation there. So again, it's a pivotal part of the hearing. It really is, that first 30 minutes. And then after that, obviously, the section, the post-conviction section of the hearing, describing not the checklist of all the things you've done, because it's kind of interesting. If you haven't done what they asked you to do, not good. But if you have done all the anger management, domestic violence, and you've done all the boxes that match your risk factors, that target your risk factors, whatever it say, now they're going to test you on it and see if you've internalized what you've learned and applied it to the first part of the hearing, which is what you did, and now explain how you learned to give us that answer about the why and how you're going to not do that ever again. Because ultimately, under step 4, because that's your step 4 work is going to be presented in post-conviction, which is, explaining your character defects, and then also helping them understand how'd you get these character defects. And the fact of the matter is, step 1 teaches us, and 12-step programs teach us, that we always will have these character defects. In general, they're not fixed, they're managed. That's why they call it recovery. That's why they call it relapse. So are you always going to be an angry person? Yeah, but I have a lot better ways of managing the anger. So that's why this chapter is important, for you to understand how all these pieces of the puzzle that you've gathered gets presented. So I don't know if I went off too much of a tangent, because I usually go somewhat on a tangent, but what do you think, Joe? And then once you're ready, let's turn it over to Mike and see what he's got going.
Yeah, just as by way of follow up, yeah, I like how you put it regarding being accountable, and then later on talking about the change and what you've done to make that change. So yeah, you put it really well. And if it is, if you do have some recent disciplines, then you're on the hot seat right off. But yeah, it's your chance to be accountable. It's your chance to tell about the change and how you do manage those character defects that you had in the past. And you brought up anger, and of course, no matter what course you're always gonna be angry. Everybody gets angry. It's just a normal human emotion, secondary emotion, and it's how you deal with it. Anyways, that's my follow up, and
And then just one more thing,
mhm.
new to these hearings, and just to strengthen what Joe had said earlier, is that some of these commissioners, I've had hearings literally where they only asked about the
Oh,
recent write-up. So if there was you just got in a fight with someone 6 months ago, they only asked about that, and barely asked about the life crime, and barely asked about plans for parole, because they're like, we're not granting you in the face of that write-up. Jennifer Schaefer says it's 3 to 5 years clean in her written structured decision-making framework, the new one. And so no matter how hard and how much I try to finesse my presentation to my clients, and I tend to be kind of a radical honesty and hopefully radical acceptance with some of these people that I represent, it's tough, because they're like, then they get into extremely defensive mode of, what do you think are my chances? I'm like, you're not going to be granted parole. And I'm trying to learn to be better about saying that, but
mm,
I just really have trouble not being honest right up front with people, instead of some attorneys may, because they try to soften the blow to say, well, let's see what happens, and this and this and that, because they realize they're up against somebody who could get very defensive, angry, and hostile with them when they confront them with the truth, because that's the nature of antisocial personality disorder, narcissistic personality disorder, and borderline personality disorder. So cannot accept criticism easily, and that's a lot of times why they lost their temper during a crime or whatever. I mean, it's a pretty quick way to find out if you are dealing with a narcissist as well, and the antisocial personality disorder is pretty obvious. But again, knowing that up front, and I've been trying to tell these people that the commissioners have really shifted gears about these hearings. I've had hearings go 20 minutes on stuff. And then you scramble at the end to go, okay, clarifying questions, let's find out. Because you want to mitigate, at least for me, I'm trying to mitigate at least. I know, okay, you're going to deny him. Maybe we could try and get it to a 3 and not a 5, right? But they've shut down the hearing so fast, and then they limit your questions to clarifying questions to 10 minutes. And that's why it's so important, like we talked about a few weeks ago. Oh, I got to let Mike back in. Sorry about that. You're here now. So
No worries.
We talked about this a few weeks ago about, really work with your lawyer and listen to the lawyer about what documents get prepared and what documents don't get prepared, because there's all this extraneous documentation that they don't really want, and there's documentation that they really do want. So if you have this write-up, or your loved one has this write-up, and it's a year ago and it's a fight, or it's a 6 months ago and it's a cell phone, or whatever it is, mitigate. Have that prep cell phone class, have another anger management class, have a bunch of programming, do a bunch of work, 12-step work to really work on, identifying your character defects, and then learning how to express that to somebody else, the exact nature of those character defects to another person, and really practice your testimony, being accountable, being remorseful, knowing all the impact and everything else. So you can load up the hearing in your documents if they're going to cut you short in some ways, by loading up remorse and accountability and that sort of thing, so that maybe you could walk out of there with a 3-year denial in the face of a recent write-up, rather than a 5-year denial in the face of a recent write-up, especially for some of these commissioners, especially if they have a long history of write-ups and that sort of thing. So you missed not too much, Mike. We were just about to switch it over to you, and then I filled in while you got reconnected. So please go ahead and let us know what's on your heart about this particular topic.
All right. Before I delve into the hearing itself, you were talking about the chronos and certificates and all that. All right. So I've seen guys go in there with a folder that's, 4 inches thick full of certificates and chronos. And then they get denied. The important thing is not the quantity of what you have. It's the quality. Be up, know everything that you're taking in there. Be able to show that you've internalized it. That's more important. If you have 5 or 6 good groups that you've done in the past year or 2 years that you can just get into and internalize and give them the meat and potatoes of it, they are going to look more favorably on that than having 30 in the past 4 years that you can barely talk about. Oh yeah, you've got the chronos, you've got the certificates, but what good are they doing you? Focus on what you can internalize. And the other thing is, you don't need to bring all those certificates and chronos in with you. You don't need to put them in your board packet, because if it's in your C file, they already have it. So the less stuff that they need to read from you when you turn it in, actually the better. And I hate to use the term minimalist in any sense towards the board, but when you're putting your parole packet together, get rid of all the extra junk. Minimize your packet to what you actually need. Keep it to a point to where you address your remorse, your empathy, to where you address what you're actually going to talk about with your self-help. And you're not going to include all the paperwork. You're just going to mention it. Make an outline. And then the big thing, like Elizabeth was saying, is if you have a write-up in the last year or so, before you go to board, the first thing they're going to look at that is, okay, you're still practicing criminal thinking. Get ahead of it before you go to board. Address it. Take groups and internalize those groups to be able to explain to the commissioners, this is what was going through my mind when I did this. I was still in that criminal thinking phase. And here's how I'm addressing it now. These are the tools I'm using, and this is where I learned this. And I'm not going to say it's going to get you a grant. I've known 2 people out of probably 100 that I've known that have gone to board that have done something similar, that have gotten grants, but it will make the difference between a 3, 5, or 7-year denial. And that's the important thing. At that point, you're going in with a write-up already. You're not shooting for a grant. Let's be honest. You're shooting to get the best outcome possible for what you're taking in there. And what you're taking in there is criminality. But you're also taking in there the fact that you recognized it a little too late, but you're still working on it. And it will make a difference in how the board views you. Like I said, you're probably not going to walk out of there with a grant, but you can walk out of there with a 3. And that 3 is 1.5 years for you to prepare and get ready. If you do everything they ask you, you follow their roadmap, you take the specifics that they want you to take as far as self-help classes, you continue your education, you continue doing what they ask you, you'll go back within 1.5 to 2 years, and if they see you've internalized it and you're taking accountability for everything, just like I did, you can walk out of there and be about 155 days from being a free person. And that's where the difference comes in. We have to be accountable. We have to be honest. All right. The other thing is, and we're going to get into that, something that I didn't hear Joe or Elizabeth mention was the 1030, the confidential information against you. It will come up. In my first one, I had one come up. One that I didn't know existed until about 3 weeks before board. But in my case, I was removed from a yard for destroying a weapon. My mistake there, A, was not reporting it. B, trying to handle it myself. And C, trying to justify it. So when I went to board the first time and they brought this up, the 1030 stated that I was in possession of an inmate manufactured weapon. Well, the bottom line is that was very true. I possessed the thing long enough to destroy it. So when the commissioners asked me about it, I said, yes, I did have possession of this weapon. And here's what happened. Yes, I explained myself. I took accountability for it. And, I ended up with a 3-year denial. That was only part of it. But being accountable for it right up front and owning our participation in whatever the confidential information is important. Because if you're doing something that is outside the purview of the law and somebody drops a kite on you at 1030, it's going to come up. So you're better off facing it head on. If you are culpable in it in any way, shape, or form, if your neighbor was selling drugs on the bunk next to you and you didn't ask to move because there's drug activity going on in your dorm, own up to it, man. Because by doing so and not asking to move and giving the reason why, you are facilitating, you are enabling this crime to happen. So you're almost as guilty and culpable as the guy that's actually selling it, because you're turning a blind eye to it when it's right next to you. Be prepared to explain that. That 1030, if you do not take responsibility for your actions, it will bite you in the butt. I've seen people go in and they go, oh, well, they had all these 1030s. Well, first off, you knew about them weeks in advance. Why didn't you prepare for them? Your counselor is going to call you in. He's going to give you form to sign. He's going to send you a copy of not the 1030 itself, but the information that was given stating what was reported. Not by who, not where, but what. So if somebody said you're selling drugs, you're ready to clarify that, because if you were, it can really go against you. And if you address the fact that, like I said, if it was going on around you and you were in a group like that and you didn't try to get out of it, it's going to bite you in the ass. Own it. Address those 1030s as soon as possible. When they start talking about them, take responsibility for your own actions or your own inaction. Because inaction can make you just as culpable as action. Why didn't you move out of that dorm? Why didn't you go to the podium and say, hey, there's drug traffic going on in my dorm, I can't be in there? By taking inaction, you have made a choice to enable culpability. And that's what the board's going to see. All right, so shifting gears real quick. After the ADA interview, as far as the board, my commissioner on the second hearing asked me one simple question before he got into rediscussing the crime. Why were you denied last time?
Mm-hmm.
And that is something that we all have to be prepared to answer if this is a follow-up board. Why were you denied last time?
Really important, Mike. Thanks for remembering that. Yeah.
Yes. And
Yes.
What have you done to address those shortcomings of the last
Right.
hearing? Exactly. Mm-hmm.
Right. And I came out straight up and explained that regarding my some of my disciplinary history that we talked about, I minimized. And during the psych evaluation, I fell back on denial and criminal thinking when I denied the depth of my gambling addiction. And when it came to discussing the weapon that I destroyed, I minimized that a bit too. And by addressing the fact that I did have minimalization and denial and criminal thinking as the three key factors of being denied for parole the first time, he went in there knowing that I had already done my work to correct these. Between the stuff that I'd submitted and the sheer fact that I walked in there and I was transparent, I showed that I internalized what the board said the time before and that I addressed it. And don't be surprised if you're asked this question on your secondary and tertiary boards if you have to go that far. And then the commissioner got into talking about my life crime. And he wanted to know what was going on in my state of mind there. So the first thing I did was I explained the moments leading up to my murdering Craig and the impact of that. But I also took a moment to ask for his indulgence, and I went back and I told him, everything that I did that night that led to me murdering this man didn't occur in just a few minutes. This was a buildup. And this buildup started with the lessons I learned as a child. This is where I learned to harbor anger and to push it down. And this is the events that led up to me boiling up to that point. And this was the trigger that I pictured, or that I felt caused this release of anger to such a degree that I murdered a man. And I went to it and I explained not only the act itself, but the causative and contributing factors both, without using a bunch of lingo and a bunch of jargon. I just said, hey, this is what happened. This is the events that led up to it, and this is where I learned to deal with my anger and my addiction in such a way. Just enough information that they knew that I internalized it and that I could express it. But it's important to be able to connect each one of these dots for the commissioner. Because even connecting those dots, he went back and asked clarifying questions. But because I did all of my groundwork, I could go back and clarify each one of those little things he needed clarified. Then comes a tricky part for a lot of people, the probation report. So, when the commissioner asks you about your life crime, one thing that people don't take into consideration is the court transcripts and the probation report are fact. By law, they are fact.
The
So if
probation
we go
officer,
and
wait, whoa. The probation officer's report is hearsay, not fact.
okay,
It is
well,
something they listen, they
Well,
look at. Yeah,
they-
so be
you know,
careful
they treat
talking
it
about this, Mike,
in a
because I don't
legal
want to.
sense.
I just slow down. Let's be careful talking about this because I don't want to give anybody the impression that you have to regurgitate something that's in a hearsay document or even an appellate
Okay.
decision. So, because there's a lot of law around that and there's a lot of misapprehension about that. So,
okay,
just,
well,
you
know
know,
what? You're both right.
refresh the memory,
You're
refresh
both
the
right.
memory on the content,
right.
but talk to your lawyer
And
about whether or not you're going to
Right.
regurgitate content or not.
And that's just it. A lot of times with this probation report, if you stray from it an iota, I've seen denials as much as 7 to 10 years from just straying from the probation report.
And that's not because you strayed from the probation officer's report. That's something to do with a whole context of situation around that. So
Okay.
I think, yeah, well, let's be careful because that's a topic
Yeah. Well, and
of itself.
so the probation report though is very important because if you stray far from it, they can use it against you. Just be aware of
They
that.
can, if it's absolutely implausible and you don't have a good reason for straying from it. So yeah, be careful because I'm a lawyer and I have to make sure that I don't misrepresent the law on this channel because there's liability attached to that. So just talk to your lawyer.
Yeah, that's the impersonation that we've been given over the years is that, you know,
understood, and
if
it's the wrong one, and there's a lot of misinformation around it, so I don't want to keep repeating it on this channel. And I do this a lot, and Joe knows that I do it, and I'm like, stop. I have many grants of parole where people did not agree with the probation officer's report because it's all in context. What's in context of what happened, including being identified as a shooter and you're not even at the scene. So it is a tricky prospect, but you do need a good lawyer that understands the law behind that. And a way
I think that is important.
You know,
fortunately, I had a good lawyer. Okay, let's move on from that though. The deputy commissioner,
wait,
when he starts addressing.
Before we move on, by the way, I want to say that you're both right. And the bottom line is take responsibility for your role. And no matter what the probation officer's report says, but you need to be mindful of it and you need to have a serious discussion about it with your attorney beforehand so you know how you're going to handle any kind of discrepancies between what happened and what's written in the report. But you're both right. So thank you, Mike. And as usual, you hit it out of the park.
All right. So let's talk about the deputy commissioner a little bit. So in both cases, the deputy commissioner, he started off with asking me about my self-help. Now, my second deputy commissioner, not as much because he read my previous transcripts, and he read the writings that I did for my self-help. He only asked me a few questions, but they will address your self-help. So be prepared to go through it. My first deputy commissioner questioned me aggressively over my anger management. So be prepared to be triggered with the anger management aspect of it, because they will push buttons. She tried to push mine, and I refused to snap at her. And I think that's one of the reasons that I only got a 3-year denial instead of a 5, is because I was able to keep my cool. They will ask you a lot about different aspects of your self-help. And sure, it's okay to give a few of the acronyms and things like that, but don't rely on that. Rely on your internalization. What you can explain to your deputy commissioner and make them understand that you've consumed this information, you've put it to use, you live it daily, is the more important aspect than the, knowing all these 9,000 different acronyms. Because at the end of the day, we only use 3 or 4 of them during the course of a day period. We're not going to use, I took 14 classes. I'm not going to use all 32 acronyms I use there all day. Let's be fair. The biggest ones that I use every day, I have Q-tip, which is quit taking it personal. And then I use my stop and halt techniques, which are anger management techniques that get me to stop, analyze my situation, and they also get me to stop, breathe, and think about what's going on. So when I'm triggered, I rely on basically 3 things for anger. And that gets me through my day, and it really, really gives me depth to my perception of what's triggering me. And I'm able to deal with it in a healthy manner from that point. We don't need all this extra stuff. Know what you know and share it. Don't try to dazzle them with a bunch of BS, because they know more about self-help than we do in most cases. They know the 12 steps inside out, backwards, upside down, and forward. They know probably more for anger management than I could dream up. They've been doing this for a long time. Don't go in there and try to bullshit them, because they can spot it. Just go in there and know what you know, internalize it, and show what you've internalized. And then the deputy commissioner may ask you, like my first one did, some clarifying questions about your life crime. My first deputy commissioner was very adamant about it, and she had a string of about 7 or 8 questions she wanted clarified. So don't be surprised if the deputy commissioner brings up the life crime. It can happen. Yeah. Let's see. Moving on from there, the deputy commissioner will also talk about your remorse letters in some degree or fashion. I know my last deputy commissioner, he was enamored with my remorse letters. And I think in the transcript it said at least twice, he kept saying, people should read these to understand them, to understand how they're done. And the thing is, when I wrote my remorse letters, I wrote them from the heart. This time, the first time I talked about the severity of the crime and the damage that I did. In my second remorse letters, I talked about the kind of person my victim was. I talked about who he was and what I'd stolen from his family and the impact of it. And I explained that, there's nothing in the world I can say or do to ever to ever voice what I truly feel about taking his life. And there's nothing I can ever do to, show the degree of remorse and sorrow that I have. Nothing can ever make this right. But in the closing of the letter, I pointed out that I wanted them to know the memories of Craig that I had and what kind of a person he was, even though I was really messed up at the time, and how much he tried to help me. And the letters, they were something I needed to get out there. But, there's a certain amount of format that your attorney may want you to follow. But in the end, let your attorney help you speak from the heart. Don't just go off on a tangent, but let your attorney help guide you. But speak from the heart. Because ultimately it's our empathy and our compassion, along with our insight and internalization, that's going to get us out of here. It's not, strictly just a bunch of self-help and all that. You have to show that you are really, truly, deeply remorseful for your acts. You have to show the inside of what you've done. And you have to be willing to take accountability for it. And that's what these letters are. They're our chance to give a voice to all of that and let our victims' families heal. Or at least let them understand where we're coming from and what happened, so they can make their own decisions if they want to heal or not. That's their prerogative. That's their right. But it's also our chance to put it out there. And most of the time, our victims' families may never even read these letters. But we need to do them in a manner that we don't cause more harm, and in a manner that we address what needs to be addressed from the heart. Let's see, and then moving on from there, excuse me for a sec. Be able to show a good parole plan. I laid out a 5-year plan for my parole agent, starting with day 1, week 1, month 1, year 1, year 2, 3, 4, and 5. And these are my goals to achieve along that path. And you don't have to be as extensive as I am. I tend to be a little bit anal on things like that and want to go as insightful as I can. But as long as you have a solid plan that includes how you're going to continue your recovery and your rehabilitation, how you're going to go about getting a job, how you're going to make sure that you make your meetings, how you're going to make sure that you're available for your parole agent when he needs you to be, how you're, one of the big things is how you're going to address your restitution when you get out. That doesn't go away, folks. It's still there. And I've set up a schedule for my restitution. I work with my parole agent, and every time I get paid, or once a week, depending on when I get a chance to get to my parole agent, I make a very small payment to my parole or to my restitution because, I'm not making a whole lot of money right now, but it doesn't matter. It's that showing that I am putting forth the effort to fulfill my obligation and be accountable. And remember, as lifers, we do not get off board the same way other people, or parole the same way other people do. As my supervising parole agents, my parole agent's boss explained it to us in a lifers meeting last month, we're going to go before the board again. this time not in person, but we're going to submit a new parole plan to the board explaining why we feel we should be taken off of parole. It's going to include the parole agent's recommendation, and it's going to include all the things we've been doing. So little things like making those restitution payments, volunteering with groups, giving of your time, doing the programs you're supposed to do, and getting a job. When you go to board that second time to get off parole, it's going to make a difference. Just because you get a grant of parole from inside the prison doesn't mean you're done with the board. Once you're out here, you're going to face them again. So be prepared. And it's going to be a lot along the same level that we went to without the interpersonal interaction with them. So be prepared. And then let's jump ahead to my closing statement. I wrote my closing statement out and I submitted it to the board the first time. And then I made a statement off of that. I stipulated that I'd given them that, but I had to speak from the heart, and I did. And then in the second hearing, I mostly stuck to what I wrote, but I didn't present it beforehand. I worked with Elizabeth a little bit on my closing statements, and between us, we tweaked it and modified it to where she would tolerate it, and I was happy with it. But again, it was from the heart. But it wasn't all about me. It was about my victim and my victim's family and the community, with a little bit at the end about my remorse and what I'm doing in the future to make things better in this life and in this world. And that closing statement is just as important as everything else, because if you go in there and you stick your foot in your mouth, one thing I learned in Toastmasters is the last thing you say is often the first thing they remember. So if you go in there and you just give an absolute wonderful interview at the hearing, and then you go in there and you stick your foot in your mouth in the closing statement, you can hurt yourself, because that's the first thing they're going to talk about. It's the last thing they heard. So be prepared, listen to your attorney. And, I'm hard-headed. I didn't want to say everything the way Elizabeth wanted me to say it. But we compromised, we worked around it, and we came up with a closing statement that we both were at least somewhat happy with. And I got to say my piece, and I got to fulfill most of the format that she wanted me to follow to get the point across and not talk about certain things that she didn't want me to talk about. And it worked. It was a good, strong closing statement. It touched my heart saying it, and I think it made an impact on the commissioners as well. So we have to be mindful of each one of these steps. Each one of them on its own is important. Some may be a little more important than others, maybe not. But taken as a whole, this paints a massive picture of who we are. If we cannot follow certain simple guidelines, even during the course of a hearing, that could hurt us. Don't argue with the commissioners. Don't cut the commissioners off. Use your active listening. Use your effective communication skills. Because those little things, again, we could present all the great information in the world, but every time the commissioner opens his mouth and I go to say something over him, guess what? I've just alienated a commissioner. That could set him in a bad mood and show, hey, this guy is not able to follow the rules. just a simple rule of conversation. How can I let him go if he cannot carry on a conversation? Following simple rules of etiquette. You know, you piss off the commissioners, that's the last thing you want to do. So, you know, just be mindful. Listen to your attorney. Your attorney is going to give you the best advice they can give you. They're more briefed on the law than any one of us is. I don't care how many years we've studied to be paralegals or jailhouse attorneys. You know what? Here's my simple take on jailhouse attorneys. They're still in jail. They're still in prison. They may help some people get out, but the bottom line is they're still in prison. So listen to the people that are actually successfully getting people out from out there. Don't worry about the jailhouse attorneys and all that, because they're in the same place you are. They're in the same boat you are, and they're not out yet. If they were really that knowledgeable and that skilled, they'd already be out there. So take that with a grain of salt and trust your attorney that you either hire or is assigned by the board for you. And that's probably the biggest, most important piece of advice I can give you. Because if I hadn't listened to Miss Ackpenny on my first hearing, I'd have walked out of there with a 5 or 7 probably. If I hadn't listened to Elizabeth, I might have gotten another 3 instead of getting a grant. Because she did help me a lot with clarifying and streamlining some of the stuff I needed and preparing to really talk to the board the way I needed to. So trust your attorneys. Vital. So with that,
Very
I'm going to
well
hand it
put,
back
Mike.
over to you guys.
All right.
Anything else, Joe? I'll give you the last word.
No, I'd just like to say Mike hit it out of the park as always. His what he said was spot on. So thank you for that, Mike.
You're welcome.
Okay, Joe, what's next? What's up next?
What's up next is it's going to be strategy number 20.
Yeah.
Be brutally honest.
Ooh, that'll be great. That'll be great. That'll be great. I love it. Looking
That
forward to
hurts
that.
egos a lot.
Yeah, we don't like that.
Right.
No.
Nobody likes to be honest, I noticed.
Yeah,
I
especially
hate
when
when
it's about themselves.
somebody says makes a statement. I'll be honest with you.
Oh,
You know
no.
what? And when they say that, it's like, you mean up to this point you haven't been honest?
Oh, boy.
Right?
Yeah.
All right. So we'll have some fun with that. And I'll see you all next week. And thank you so much for your participation. I'm off to feed some pigs because my husband's not here. That's why everything's been going haywire for me off camera. But enjoy yourselves today and
Thank
next
you.
week.
Absolutely.
All right. Very
Okay.
good. Is also
And I'm getting on the road in a few minutes, so
okay.
Great.
you guys have a great day. See you next week.
Okay.
Okay.
All right.
Be safe.
Bye-bye.
Thanks,
Will
guys.
do.
Bye
Showing
now.
up. Bye.
Bye.